बोलो बोल दो।
किसमें सर? हाँ स्टार्ट करो सर।
कर दिया बोल दो। हाँ बोलो।
हाँ हो गया सर।
बोलो बोल दो।
बोलिए सर।
किसमें सर? वो भी आवाज़ कैच कर लीजिए।
हाँ स्टार्ट करो।
कर दिया बोल दो।
बोलो चुप हो जाओ।
माइक नहीं ऑन है। वो भी आवाज़ कैच
हाँ स्टार्ट
कर दिया। या दूसरे की आवाज़ आ रही है, वो नहीं आ रही है।
इनकी आवाज़ नहीं आ रही है।
Thank you, Pranav. Dear panelists of the Grand Championship round, participants, colleagues, and students, a very good evening to all of you. On behalf of the Jindal Global Law School, the Jindal Moot Court Society, and the organizing committee of the 13th Vis Moot, it gives me great pleasure to welcome you to the Grand Championship round. The Vis Moot Court has established itself as the largest and most prestigious moot court globally in the field of international commercial arbitration. The Indian Vis Moot, which Jindal Global Law School has hosted since 2017, has become a prominent feature in the Vis calendar and has attracted teams from various law schools across the country. The Moot aims to bring together teams and provide them with an extremely high quality mooting experience. Teams that have done well in this pre-moot have regularly gone on to excel in both Vienna and Hong Kong. This year is special for us for two reasons. One, the Vis Moot West, Vienna, is celebrating 30 years. And two, we at Jindal Global Law School are hosting a physical moot court for the first time in 3 years. After having conducted the previous two editions of this moot court from behind computer screens, we are delighted to host this event and all of you in person. I now wish to introduce our esteemed panelists. Ms. Sneha Janki Raman is a partner in the dispute resolution practice group of Khaitan & Co. She is a qualified English solicitor and an advocate on record with the Supreme Court of India. Ms. Janki Raman specializes in international commercial arbitration and insolvency resolution. She has been advising and representing a wide range of clients, including multinational corporations and leading Indian conglomerates in international as well as domestic arbitrations and allied court proceedings, especially in the infrastructure, technology support, pharmaceuticals and life sciences and joint venture spaces, which are her areas of expertise. Thank you so much, Ms. Janki Raman, for being with us this evening. Mr. Aditya Vikram Jalan is a partner at AZB, Delhi. He specializes in arbitration and dispute resolution and has over 12 years of experience in these areas. He has advised clients on a wide variety of commercial disputes in international and domestic arbitrations, regulatory investigations, and white-collar crime defenses. He has represented clients in ad hoc as well as institutional arbitrations across multiple jurisdictions. He has been recognized as an up-and-coming dispute resolution lawyer by Chambers and Partners Asia Pacific and by Chambers and Partners Global. He has also been recommended for dispute resolution by Legal 500 Asia Pacific. Mr. Jalan, thank you very much for joining us this evening. Mr. Shashank Garg is a seasoned dispute resolution practitioner with over 15 years of experience appearing before the Supreme Court of India, the High Court of Delhi, and various other judicial and quasi-judicial forums. He regularly appears as counsel and sits as arbitrator in ad hoc as well as institutional arbitrations. He is the Joint Secretary of the Society for Construction Law India and the co-chair of their Young Leaders Group. He is a member of the ICC Commission on Arbitration and ADR and member of the arbitration community of the Delhi International Arbitration Center. Between 2017 and 19, he was ICC-YAF's Regional Chapter Coordinator, India. Mr. Garg is the editor of the Arbitrator's Handbook, published by LexisNexis in August 2022, wherein contributions of experts from across the globe have been received. He is also the editor of Alternative Dispute Resolution, The Indian Perspective, published by Oxford University Press. He has contributed chapters to various celebrated books, including a chapter with late Professor Martin Hunter in the Handbook on International Arbitration. He was the convener for the first Delhi Arbitration Week in 2023 and is a fellow of the Chartered Institute of Arbitrators. He is also a member of the editorial board of the DIAC Journal and the Indian Review of International Arbitration. He also serves as visiting faculty at various renowned law schools across the country and is regularly invited to be a speaker at dispute resolution events across the globe. Mr. Garg, thank you very much for taking the time for us. Mr. Toshit Shandilya is a partner at AZB Delhi. He has over 9 years of work experience and is a part of the competition antitrust practice group. Mr. Shandilya regularly assists multinational clients in international and domestic cartel investigations, post-M&A disputes, merger control matters, and compliance investigations. He also focuses on regulatory issues and advises clients on a variety of contractual and compliance issues. Thank you very much, Mr. Shandilya, for being here with us today. And Mr. Vikas Kumar Jha is a partner at Cyril Amarchand Mangaldas. He is a gold medalist from National Law Institute, University, Bhopal. He's been in the profession and has been associated with what was formerly Amarchand Mangaldas and now Cyril Amarchand Mangaldas for 2 years. He has extensive experience in dispute resolution and focuses his practice on commercial litigation before various forums, including the Supreme Court of India, various high courts, the NCLAT, the NCLT, and PMLA. He also has extensive experience in arbitration and court proceedings arising from arbitration. Further, he has appeared in trial courts and has a fair amount of practice on the original side. He is a qualified advocate on record at the Supreme Court of India. Mr. Jha, thank you very much for your presence here today. It is our pleasure to host each of you at OP Jindal Global University, and I thank you for taking the time on a Sunday afternoon to make this trip to Sonipat to judge the Grand Championship round of this pre-moot. On behalf of the organizing committee, I wish to express our deepest gratitude to Professor C. Rajkumar, the Vice Chancellor of OP Jindal Global University, Professor Sridhar Patnaik, the Registrar of OP Jindal Global University, Professor Dr. S.G. Srijit, the Executive Dean of the Jindal Global Law School, Professor Karan Latyan, the Director of the Moot Court Society, Professor Menaka Nair, the Associate Director of the Moot Court Society, and all my fellow faculty colleagues who have been instrumental in helping us organize this event. A special word of thanks for the IT and AV team for all their help with organizing rounds across the 2 days of events that we have had. Last, but certainly not the least, I would like to thank all members of the student board who are a part of the organizing committee of the Vis Moot Court, as well as the student volunteers who have individually and collectively made tireless efforts over the last many months to deal with the various challenges and bring this event to fruition. I can imagine that everyone, especially the participants, must be anxiously waiting for the round to start. So I won't take much further time. And without further ado, I will hand over the stage to the panelists as well as the finalists. May the Grand Championship round begin, and may the best team win.
Commence the proceedings now.
We couldn't hear you.
Am I audible now? Yes, we can commence the proceedings now.
Members, the parties have agreed to a procedural order of respondent bringing the challenge on jurisdiction first, with a response by claimant, followed by a round of rebuttal and sur-rebuttal, and then the claimant bringing the challenges on merits first, followed by respondent responding, and then a round of rebuttals and sur-rebuttals. Each speaker has reserved 14 minutes for their speech and 1 minute for the rebuttals.
Members, with your permission, I'll begin. Should I?
Your mic's not working.
Is my mic? Yes. Am I audible to all the members and panelists? Yes. So, good evening, members of the tribunal. My name is Mr. Mrityunjay Roy, and along with Mr. Abhyuday Singh, I would be representing the respondent, Equatoriana Geoscience Limited, in these proceedings. I shall be taking 14 minutes of your time to advance the respondent submissions on the first two issues. Members, the claimant relies on a logic of convenience by ignoring the law as well as the facts. The claimant knew before signing this agreement that respondent as a state entity could not sign international arbitration agreements. Yet, it wants to bind us to these proceedings. Moreover, they know that Equatorianian authorities are investigating whether this contract was procured through bribery. Yet, they want you to proceed as if nothing is happening. Clearly, the claimant wants to rush to an award before all the facts can come to light. This should not be allowed. Therefore, I make two submissions before you. First, that this tribunal does not have jurisdiction to decide this dispute. And second, that even if the tribunal assumes jurisdiction, it should either stay or bifurcate these proceedings until the Equatorianian investigation in relation to this contract gets over. Members, on the first issue of jurisdiction, I argue that this arbitration agreement is invalid because the respondent did not have capacity to sign this agreement. It is an elementary principle of contract that for any agreement to be binding, the party signing it must have capacity to sign the agreement. In the case of companies such as the respondent, its capacity is governed by the law of incorporation, which in this case is the law of Equatoriana. Now, under Equatorianian law, I would point the tribunal to Article 75 of the Constitution as reproduced on page 30 of the record. If the tribunal is with me, I read paragraph 21 on page 30, the last 4 lines of that paragraph. In contracts relating to public works or other contracts concluded for administrative purposes, the state of Equatoriana or its entities may submit to arbitration only with the consent of the respective minister. If the other party is a foreign entity or the arbitration is seated in a different state, Parliament has to consent to this submission. Members, this contract was signed in relation to the Northern Part Development Program, which is a mining program by the government of Equatoriana. Further, the drones under this contract were custom made specifically to do geospatial exploration for the Northern Part Development Program. Therefore, this is clearly a contract in relation to public works, and therefore the respondent as a state entity needed parliamentary approval for this international arbitration to become binding. Since that parliamentary approval did not come, the arbitration agreement is invalid, and this tribunal does not have jurisdiction.
I will just interrupt you for a couple of questions. First is, isn't it fact that ignorant law actually considers only actual infrastructure works as opposed to the reconnaissance works for which you use the drone as part of its administrative requirements for the purposes of parliamentary approval? And second, I understand that there was a publication in the Citizen which post the contract signature was widely circulated to show that the Parliament, despite the lack of parliamentary consent, this contract had been entered into and the government did nothing about it. So isn't there something to be said about principles of good faith and ethical on Parliament?
Certainly, Madam Arbitrator. In relation to the first concern, I would take you to page 47 of the case record, clarification 29. Does the purchase and supply agreement qualify as an administrative contract requiring parliamentary consent? the existing case law covers only cases for actual construction of infrastructure, and there is no decision yet on preparatory contracts. Therefore, Madam Arbitrator, it is not as if Article 75 does not cover preparatory contracts. It is just that a case on that point has not come before Equatorianian courts.
Would it be fair to say that this tribunal can take an independent view on whether or not this contract actually is covered within the administrative contracts?
Certainly, Madam Arbitrator. But if I may point out on the second question of good faith, before entering into this contract, the claimant was aware about the applicability of Article 75. I would take the tribunal to page 18 of the record, which is the statement by claimant's in-house counsel, Ms. Horatia Porter. If the tribunal is with me, I read paragraph 6 on page 18. At the same time, my understanding was that the agreement as a contract for public infrastructure required an approval by the minister in charge, which was in this case the Minister for Natural Resources. In addition, an approval by Parliament is required if such contracts contain an arbitration clause. Members, therefore, this shows that the understanding of both parties throughout negotiations and signing was that this is an administrative contract under Article 75, and therefore it required parliamentary approval. Thus, knowing the law, when the claimant entered into this contract, they assumed the risk that parliamentary approval may not come in future. The respondent or the government never made any qualms about this or misrepresented that parliamentary approval is not important.
Mr. Counsel, I think the question is slightly different. The question is whether the members of the parliament or the parliament collectively was not informed about this contract. If they were all along aware of this contract and the minister giving his consent, would it be fair to now say that just because there is an absence of an approval from the parliament, we would want this tribunal to not have these proceedings and there is no jurisdiction to do this? So it's the knowledge of the parliament first. And second, if the parliament was aware that such a contract has been entered into and no consent has been taken formally of the parliament, what actions were taken, what information was remitted, was sent to the claimants here? Was there any attempt by the minister or the concerned party to convey that possibly there should be a delay in implementing the contract? When none of that has happened, you proceeded with the contract, and all the stakeholders are aware about it. How fair it is to take this argument at this stage?
Mr. Arbitrator, on the second aspect of your question regarding whether the respondent informed the claimant about the dual requirement, I would take you to page 35 of the record.
No, it's not about the dual requirement. That's, I think you've made a proper case by showing us para 6 on page 18 that the claimants were very well aware or their understanding was that such a requirement is there. We are now at a slightly nuanced stage. The contract has been entered. The consideration has been exchanged. The parliament is aware of what is happening, and still there is absolute silence. So the minister and the respondent, our prima facie view is attempting to convey that everything is fine, and there is the record states that the minister has said this is a mere formality.
Mr. Arbitrator, on the first aspect, but the respondent always considered this to be an administrative contract, but since the respondent is merely a company, it cannot control the decision of Parliament, which the Parliament must make on its own. Secondly, Mr. Arbitrator, the respondent, knowing this, assumed that risk before entering into this contract that parliamentary approval may not come. So on the formality aspect, members, it is true that this is a formality under Equatorianian law, but this is a formality in the same way that it is a formality under the New York Convention that an arbitration agreement be in writing. While yes, that is a formality, if the arbitration agreement is not in writing, the arbitral award is equally unenforceable. Therefore, since this is a critical formality for the validity of the arbitration agreement, this not being fulfilled invalidates the arbitration agreement and the jurisdiction of this tribunal.
I have a small question on this point.
Certainly.
In fact, it was to be put up before the Parliament for its approval on 27th November 2020. The same para 7 of 18, page 18. So it was, of course, it was a consensus side item between the parties that even this requirement is going to put before the parliament. But of course, because of the change of government, whatever was done during the time, they were not able to put it to the parliament. So can we say that in terms of consensus side item between the parties, the claimant hearing and the respondent, the claimant also wanted it to go before the parliament of the respondent and an approval to be given for this arbitration clause. Just because it could not be put for the parliament, can we say that the claimant did not want it an approval from the parliament of the respondent? Because see, if it was a case where there was no discussion whatsoever of it being put to the parliament, I understand that you can't take away that right from the parliament of a country. But this was envisaged, this was going to be done, but because of one or the other reason, this could not be done. So what do you want to say about that?
Certainly, Mr. Jha. On that point, the respondent made all efforts from its end to ensure that the procedure may be followed. If I would take you to question 29 on page 47 of the record. Page 47, question 29. I read from the second line onwards. Respondent, however, had always considered the contract to be one falling within the consent requirement and had thus asked the Ministry of Natural Resources and Development for approval by Ministry and Parliament. Therefore, members, the only thing that the respondent could do was to inform the government that parliamentary approval is required, but thereafter, whether parliamentary approval was given or not is outside the respondent's control. Therefore, knowing about all these possibilities, the claimant, when they signed the agreement, assumed the risk that parliamentary approval may not come, and the respondent did everything from its end to ensure that parliamentary approval may be secured. With that, members, if I may move on to my second submission regarding stay or bifurcation. Members, on stay, I will argue three main points to justify why a stay or bifurcation is warranted. First, because the outcome and fruitfulness of this arbitration are materially dependent on the Equatorianian proceedings. Second, is that without a stay, the respondent would be deprived of a reasonable opportunity to present its case. And third, that there are no undue delay or expense or unequal treatment to the claimant through a stay or bifurcation. Members, the Equatorianian authorities are investigating whether this contract was procured by claimant through bribery. This same issue will come up before this tribunal because the respondent has alleged that this was procured through bribery. Therefore, since the issue is the same, the Equatorianian authorities, with their wide investigative powers, would be able to collect a lot more relevant evidence, particularly from third parties, which this tribunal would not be able to collect on its own, but would be relevant for it to make its decision. Secondly, members, under Article 15 of the Anti-Corruption Act in Equatoriana, contracts procured through bribery are void. Therefore, in future, should the Equatorianian courts find that this contract was in fact procured through bribery, it's likely that the award of this tribunal would be unenforceable. Therefore, since the outcome and fruitfulness of this entire arbitral process is materially dependent on the Equatorianian proceedings, I request that the tribunal stay the arbitration until the proceedings get over.
So just one question to answer. You're operating on the assumption that the Ecuadorian court is going to find that there is actually an allegation of corruption. So let's take a situation when the corruption allegations don't actually hold true and the tribunal holds its hands. That just means we wasted time from June 2024 doing nothing with this arbitration while we could have actually completed it, and our mandate is for a time-bound resolution on this PCA route as well. So how would that scenario play out in consonance with our mandate?
Madam Arbitrator, I would answer this in 2 points. First, it is a duty of a tribunal to ensure that its award is enforceable. In light of this, it needs to ensure and look out for relevant possibilities that might affect the enforceability of this award and weigh in that risk while deciding how to conduct the proceedings. In this case, since the consequences of an award being rendered unenforceable in the event of Equatorianian courts finding bribery are very high, the tribunal must urge on the side of caution to ensure that there is only a delay of at most 1 year instead of having to conduct the entire proceedings and in the end having the award rendered unenforceable. With that, members, if I may ask for a 2-minute extension to finish my submissions. Certainly. Members, on the second aspect, without the stay, the respondent would be unable to reasonably present its case. This is because Without a stay, the respondent would not be able to show evidence from the Equatorianian investigations to prove its claim of bribery before this tribunal. Under Article 5(1)(b) of the New York Convention, being unable to present one's case is also a ground to not enforce the award. Therefore, to give the respondent a reasonable opportunity to present its case and to avoid unenforceability of the award, the tribunal must stay the proceedings. This is also because a stay would not cause any undue delay or expense here either. Members, the evidence in this case is secured across multiple different countries. Mr. Field, the main accused, is situated in Equatoriana. Mr. Blunchley is incarcerated in Mediterraneo, and the offshore accounts are all over the world. To investigate all of that, the tribunal would have to expend a lot of time and resources. If we simply wait for the Equatorianian investigation, the tribunal and the parties would avoid that time and expense and conclude the arbitration in an efficient manner. Further, no unequal treatment is being caused to the claimant because the effects of the stay fall equally on both parties.
Counsel, you say that you would not be able to place evidence of bribery before this tribunal. But this tribunal, is it going to decide upon the bribery? And why is that evidence even relevant for the consideration of the issues by this tribunal?
Mr. Arbitrator, the tribunal would not be determining the public law consequences of bribery, but bribery for the purposes of this contract. Under Article 2A of this particular contract, inappropriate payments to the respondent's employees is a condition for fundamental breach. Therefore, the issue of bribery would have to be investigated and adjudicated upon by this tribunal. In the alternative, if you do not wish to stay this arbitration, a case for bifurcation is certainly made out. Under the bifurcation, you may deal with all issues related to corruption in a second bifurcated phase, while dealing with all other issues such as misrepresentation and applicability of the CISG. Right now,
I believe time is up. So.
Certainly. If I may get 30 seconds to just make this point and then move on and conclude my submission. Certainly.
Nobody has any questions.
Members of the tribunal, am I properly audible here? All right. May I begin? Good afternoon, members of the tribunal. My name is Ruhan Shah, and I'm here today to assist the tribunal on the issues of procedure pertaining to this present dispute. My co-counsel here, Mr. Kevin Santosh, will be subsequently dealing with the issues of merits. Members of the tribunal, the crux of this dispute lies with reference to an agreement which is for the purchase and supply of drones and the arbitration agreement which is present within that same agreement. I will be referring to this agreement as the PSA during the course of my submissions here today. Simply for the sake of clarity, to provide a roadmap of my submissions, I will first be addressing 2 points. That is, the issue of jurisdiction which has been brought up by the claimant, by the respondent in the present dispute. And secondly, I will be showing that there should be no stay or bifurcation carried out with reference to these proceedings. On the point of jurisdiction, while at present the respondent has not brought up the allegations of corruption that were made in its response to the notice of arbitration, and however they have been brought up with reference to a stay, as such I will just be merely addressing them and then moving on to the issue of lack of parliamentary consent in the present dispute. With reference to corruption, the respondent in its response to notice of arbitration has claimed that by virtue of a likelihood of corruption and along with that allegations of misrepresentation, the arbitration clause contained within the PSA would be invalid. Therefore, the tribunal would not have jurisdiction to hear this dispute. However, members of the tribunal, it is submitted that by virtue of the doctrine of separability and its application to this present dispute, considering that Danubian and Equatorian arbitration laws recognize this particular principle, the tribunal would in fact have jurisdiction, considering that firstly, in the present case, the allegations of corruption relate to the PSA as a whole and are not specific to the arbitration clause within the PSA. And additionally, under Article 16(1) of the Danubian and Equatorian arbitration laws, this principle has been recognized. Furthermore, even the PCA rules under Article 23(1) recognizes this doctrine of separability. I would also like to simply summarize the case of Fiona Trust versus Privalov, where in fact it was held that even if there are allegations of corruption and the contract is voided on the basis of the same, that would not lead to avoidance of the arbitration clause within said agreement by virtue of the fact that, number one, those allegations were not specific to the arbitration clause, and secondly, English arbitration law in that particular case upheld the doctrine of separability similar to Danubian and Equatorian arbitration law here today. I'll be moving on now to the second submission, which was made by the claimants with reference to jurisdiction. That is under Article 75 of the Ecuadorian Constitution. Madam Arbitrator, you yourself brought up this very intrinsic point of the fact that this PSA ideally should not directly be considered to be an administrative contract under Article 75 and questioned the respondent about the same. I have one extremely important submission in this regard, which is that the respondent seems to have almost unilaterally characterized this PSA as such a contract which was concluded for administrative purposes and subsequently is now claiming that it may, however, be a preparatory contract concluded for such purposes. However, members of the tribunal, a very key distinction here is that both of those particular forms of contract must yet link to the actual construction of infrastructure at some stage or the other. Here, it is submitted that as per the response to the notice of arbitration which the respondent has given us, there are several steps leading to this actual construction of infrastructure. It starts off with the drones under this PSA first being used to carry out geological surveillance. Then certain natural resources will be located. Subsequently, after that, those resources will be sold to a potential buyer who at present is unknown. And once that process has been concluded, the revenue which is generated from that sale will be used to carry out actual construction of infrastructure. Members of the tribunal, on two very key points, this is an extremely untenable argument. Firstly, because considering the fact that not only is the PSA itself a lengthy contract stretched out over a number of years, but this process in and of itself is one that will take a very large amount of time. And as such, clearly considering it to already be for the actual construction of infrastructure or a contract concluded for that is extremely preemptive in nature. Secondly, the respondent themselves has absolutely no control over any stage of this particular process in the sense that there is no guarantee that they will find resources, there is no guarantee that they will find a buyer, and on top of that, there is absolutely no guarantee that they will make enough profits of this particular sale to carry out such actual construction of infrastructure at any stage. As such, it is my submission that calling the PSA a contract concluded for administrative purposes here today, or even a preparatory contract for that purpose, is something which is premature at best and completely incorrect at worst. However, members of the tribunal, in the alternative, even assuming that the respondent's representation is something that is correct, it is submitted that on the basis of the New York Convention, the respondent, based on the principles of good faith, cannot today invalidate the arbitration clause based on a lack of parliamentary approval.
Counsel,
yes.
Before you go on, you say that they have unilaterally considered this as an administrative requirement. However, your witness has herself mentioned and identified the requirement. So what is your basis of then saying that this was a unilateral consideration by them?
Thank you for your question, Mr. Arbitrator. My basis for saying that this is unilateral is that this entire time the claimants have been basing this particular contract falling under this requirement based on the representations made by the respondent themselves. In fact, they were the ones who brought up the problem of parliamentary consent first through the minister, and when further questioned about it, they were the ones who then stated and made the representation that such parliamentary consent was required. As such, this entire time, the claimants have simply operated on this particular contract falling under this requirement on the unilateral basis that the respondents were the one that made that suggestion in the first place. That is simply my submission in this regard.
But then, is it sufficient for you as a contracting party to accept the representation made by the other party till it is convenient to you, and thereafter say that it is unilateral merely because that representation is not to your benefit?
Mr. Arbitrator, I do believe in the present case that is something that can be viable, considering that at the end of the day, the claimant never based this of a presupposition that later on the respondent would use such lack of parliamentary consent, which it itself said we needed based off this representation, against us to try and invalidate the PSA. As such, considering the intent behind why the respondent is choosing to characterize this contract as an administrative one is something that is at fault. However, in any case, members of the tribunal, even assuming... Mr. Arbitrator, while we completely acknowledge the fact that the claimant was aware that such parliamentary consent was required, the fact of the matter is that the respondent was as well completely aware of this, which is why initially they did characterize this as an administrative contract and make that representation in the first place. However, today they are now claiming that on the basis of that same representation, they now have the authority to come and invalidate the arbitration clause within the PSA and therefore the agreement as a whole. It is our submission intrinsically, however, that even if it is assumed that the PSC requires such consent, the respondent is now barred from doing so, considering that all along it knew that such parliamentary consent would be required. If I could move on to that submission, much obliged. Equatoriana, Danubia, and Mediterranean in the present case are all contracting states of the New York Convention. As mentioned by the respondent themselves, the intrinsic requirement under Article 2 of the Convention is that there must be an arbitration agreement in writing. However, of course, there are certain cases in which such an agreement can be invalidated or incapacity can be claimed, as has been done by the respondent. However, members of the tribunal, on the basis of the very well-established principles of good faith, it is our submission that this cannot be done by the respondents in the present case. Swiss arbitration law, Peruvian arbitration law, Spanish arbitration law, a whole host of national arbitration statutes have recognized this particular principle, which essentially holds that you cannot invoke, and especially state-owned entities cannot invoke, internal restrictions of their own legislation to attempt to frustrate arbitration agreements that they previously freely entered into. Members of the tribunal, if I could bring your attention to page 35 of the problem. If the tribunal is with me. This is an email which the respondent has put as one of his exhibits between J.C. Blunchley and Mr. David Field, who at that point in time were the two main negotiators of this particular PSA. I'll be reading from the first paragraph, where it states that we are glad to hear that the minister does not consider the cancellation of the parliamentary debate and decision to be an obstacle to his approval of the agreement, and that the signing procedure can proceed as planned. Members of the tribunal, this clearly indicates the fact that at the end of the day, the respondent was well aware that parliamentary approval had not been given, number one, and number two, that we were going to go ahead with the signing process of this agreement nonetheless. Had the respondent had an issue with such a lack of parliamentary consent, that would have been the stage to bring this up, rather than...
If it was as clear as cloudless sky for them, for the respondents, it was as clear as for you as well, that if they don't have parliamentary consent, why? Because they may have given you assurances that it will be done. But as a party who is in this business for so long, and as an expert in this field, and when you're contracting with the state, when you know that parliament is the ultimate authority, you must also have sought for that conference with the parliament and that will be entering into this contract. What stopped you from asking them to get this permission from the parliament before you entered into this contract?
Thank you for your question, Mr. Arbitrator. The main basis why I believe that in the present case, no obligation in that regard can be put on the claimant is that we were operating on the representations given by the minister, who not just in his capacity as the Minister of Natural Resources present in Equatoriana exists here, but also exists as the chairman of the board of the respondent themselves. That same minister was the one that came and told us that you will be getting parliamentary approval and that it's merely a formality and can be achieved retroactively as well. As such, in the present case, the obligation to then get that same parliamentary approval when the respondent themselves was stating that it's merely a formality cannot possibly be put on the claimant in this regard.
Mr. Counsel, the document that you have just referred, on page 35, if you read those lines again, it says the minister does not consider the cancellation of parliamentary debate and decision to be an obstacle to his approval of the agreement. So he's only talking about himself. He's all right to still go ahead and approve, and that the signing procedure can proceed. But nowhere he says that there is no more requirement of the parliamentary debate and decision. So therefore, that is clear that you were aware that there are three steps. One is, of course, signing, which is a procedural step. One is the consent of the minister, which he is still agreeing to. And then there is, of course, a decision of the parliament that has to come. So what steps did you take thereafter to ascertain that this parliamentary approval is coming shortly or is coming your way?
Mr. Arbitrator, to answer your question, within these 4 lines at least, the phrase that we believe is actually what stands out is that the minister does not consider cancellation of the parliamentary debate and decision. That this particular parliamentary debate that is being referred to over here was the one where the minister himself put in this particular proposal to get this agreement approved by parliament.
And later on withdrew it.
Yes, Mr. Arbitrator.
Yes. So but this does not indicate that there is no requirement.
Correct, Mr. Arbitrator.
So it would be in the next set of debates or the next session, it would be put before the parliament. That's your legitimate expectation, right?
Yes.
So the question is that what did you do really in sort of a follow-up to know or to check? Because as the co-arbitrator just pointed out, you're dealing with the sovereign, you're dealing with the state. And if there are steps that have been mandated, and you are aware all along, so what are this, how are you showing your due diligence and reasonable efforts to ascertain that everything that was required has actually come?
Understood. Thank you for your question, Mr. Arbitrator. I'll be dealing with this on 2 points. The first is, as I said previously as well, we were operating based on the representations made by the minister in regard to the fact that not only was it a mere formality, but also that you could get parliamentary approval retroactively and would be forthcoming. As such, it could be necessary understood that this particular obligation would be taken up by the minister at some point after his parliamentary proposal was taken back. Secondly, however, if I could bring your attention to an email dated May 27th, 2021. This particular email was sent by Miss Queen stating that she wished to amend. Just a second, Mr. Arbitrator. This is on page 22 of the problem. This particular email is sent by Wilhelmina Queen, who works at the respondent's company. Herein, she has made an amendment to the arbitration clause. And this is post this proposal not being submitted to Parliament, and also with a lack of parliamentary consent. And it is my submission that on the basis of this, the respondent has effectively ratified this arbitration agreement and considers it as one that is approved effectively. As such, Mr. Arbitrator, I believe that the question of whether parliamentary approval should have been gotten by the claimant cannot be addressed at this stage. However, moving on, in any case, if the tribunal is of the opinion that this agreement is invalidated under Equatorian law due to such incapacity, at the end of the day, they can still apply the law of the seat, that is Danubian law in the present case. Seeing that I'm running out of time, may I simply request an extension of 2 minutes to quickly summarize? Much obliged. This is essentially based on the validation principle, which forms an intrinsic part of the New York Convention itself, and has been used in a host of cases, such as Enka versus Chubb, for instance, wherein if the law that governs the contract holds the arbitration clause as invalid, which cannot ever be the intent of the parties, they must apply the law of the seat which validates it. And considering again that Danubian law does not have any such restrictions on state-owned enterprises entering into arbitration agreements, this particular law can be used to validate the arbitration clause herein. However, now I'll simply summarize my submissions with reference to a stay and bifurcation in the present case. 2 quick points are firstly, that arbitration is based on the principle of neutrality. In the present case, considering that Danubia, a neutral seat of arbitration, has been chosen, and furthermore, the Equatorian courts are known to favor state-owned entities in their decisions. Naturally, neutrality formed an extremely big point with reference to us choosing arbitration as the form of dispute resolution. As such, today, if a stay was granted and the courts of Equatoriana would once again get this corruption dispute to handle, that would completely be going against the intent of the parties which entered into this arbitration clause. However, nonetheless, while they may claim, the respondents in this particular regard, that evidence which comes out of such a particular trial may be used and may be useful for the tribunal here today, at the end of the day, there are extremely dubious connections which exist between the public prosecutor handling this particular case and the PSA in and of itself.
Mr. Counsel, those arguments you can make when this evidence is put before this tribunal, why should this tribunal be precluded from looking at that evidence at all? Just because you have some sort of an assumption that there is a history, checkered history of the state favoring its office bearers, or there have been instances, I don't know what is the source of your information, where they have manipulated records, stuff like that. So whatever it is, I mean, let them present this evidence, and then at that point of time, you could make these arguments to basically test the credibility of the evidence before this time. Why should we be precluded from looking at this material and making our own assessment on it?
Thank you, Mr. Arbitrator. 2 reasons for this particular thing. The first being that an arbitral tribunal is meant to, as far as possible, independently analyze this particular dispute, considering that invalidity was a part of the arbitration clause with reference to the agreement. It has formed a part of the intent of the parties with reference to what should be arbitrable. And the second major reason is what essentially is my final submission, is that in the present case, arbitration has also been chosen because time is of the essence to the parties here today. The inclusion of the UNCITRAL expedited rules, while of course they do not apply to this present dispute.
Counsel, I think your time is up. In 30 seconds, what's your argument? Why there should be no bifurcation, and then we can end with that?
Mr. Arbitrator, 2 points just to quickly summarize. The first is that they would cause an immense amount of financial ramification, especially with reference to the claimant and not with reference to the respondent, thereby creating an extremely unequal situation, considering that the Kestrel Eye is now currently going out of production off the market and would make it extremely difficult to sell this particular drone, also considering that the Hawkeye is now being released. But secondly, and more importantly, this particular dispute, if bifurcated, creates a very, an extremely twisted sense in the manner that the corruption angle, if dealt with later on, assuming that this bifurcation is accepted, could potentially invalidate the first set of proceedings. And as such, they are very clearly intertwined, and this bifurcation should not happen in that regard. With that, I'd like to conclude my submissions. Thank you for a kind and patient hearing.
Members, if I may begin the rebuttals. Members, I have 2 pointed rebuttals to the claimant submissions. First, the claimant is trying to... Should we... May I restart?
Yes.
Members?
Reset the time.
Members, my first rebuttal is that the claimant is trying to mislead you on the facts and circumstances to show that somehow it was not on its own aware that Article 75 applies to this contract. Members, I will take you again to page 18 of the record, which is the statement by Ms. Horatia Porter. Members, this understanding which I showed you on para 6 about how this contract is one for public infrastructure was procured before the signing of the agreement by the claimant and before the email dated 27th November 2020, which the claimant referred to. Therefore, it was not as if it was the respondent which told the claimant that this is an administrative contract. The claimant on its own was aware that this is one. Secondly, members, they referred to page 35 of the record. I would again refer you to page 35 and point out the last paragraph on that page. I hope the above gives the minister sufficient information and arguments for his speech. Should the minister need any further information for subsequent discussion in Parliament, please let me know and we will provide them. Therefore, even after this email, it was known by the claimant that parliamentary approval is necessary, and they were signing the agreement knowing that we will have to do something to secure this parliamentary approval in future.
Well, I know you don't have time, but what is the subsequent information you sought from the claimant?
Mr. Arbitrator, we did not seek any information for them, but the fact that they offered to give subsequent information for parliamentary debate shows that they knew that even if the agreement goes through without parliamentary approval, that we will have to secure parliamentary approval in future.
But this also means that they were also keen on you getting the approval from the Parliament because they wanted this agreement to go ahead, and so were you at that point in time. In terms of, see, the primary aspect of any contract is consensus ad item, as I understand. The point what I'm trying to say that the second last paragraph of this letter clearly shows that they were keen on you telling any other information if you can give them, if you want from them, which will help you, or assist the minister in getting the approval from the Parliament. So they were, while I agree that they had the knowledge that Parliament approval is necessary, but the assurances, as they have rightly pointed out, the assurances made from the minister himself, who was also the chairperson. And if it was a contract less than a certain amount, he was the appropriate authority to give the consent for this kind of a contract. But since it is beyond a limit, of course, the parliamentary consent is required. So what I'm trying to say that, what did the respondent do in furtherance of this letter?
Certainly, members, as I pointed out in my main arguments, the respondent at the end of the day is a company and it does not control Parliament's will. What the respondent could do was apply to the relevant ministry for them to be able to secure parliamentary approval for this. And this was in fact done by the respondent. For this, I would point you to page 47, clarification 29.
Members of the tribunal, could I begin with my SOR rebuttal? Simply for just 1 minute. If I could bring your attention once again to what the respondent themselves referred to, which is on page 18 of the problem. Herein in paragraph 6, the exact statement of Ms. Horatia Porter is that at the same time, my understanding was that the agreement as a contract for public infrastructure required an approval by the minister in charge. Members of the tribunal, the phrase here as a contract for public infrastructure was not the understanding. The understanding was that based on the representations of the respondent, this would characterize as such a contract. And the understanding, in fact, was that therefore it required an approval by the minister in charge. The understanding was not that we ourselves characterize it as such a contract. Furthermore, based off of the same thing, while the respondent may believe that we previously had made attempts to get such parliamentary approval, that too was based on the minister himself coming and telling us that it would be a mere formality and could be gotten at a later stage. Additionally, with reference to the question Mr. Arbitrator posed to the respondent, I'd like to bring your attention to clarification number 30, which is located on page 47 of the problem. If the tribunal is with me. This question essentially posed is, have there been any further attempts to pass the parliamentary procedure, and relates to after this proposal by the minister was withdrawn. And here it's clearly mentioned that there were no further attempts, and not just that, but Mr. Bluntschli was aware that the debate had been cancelled and that there was no official consent to the contract. He believed that consent could be subsequently granted. As such, once again, that too was based on the representation made by the minister, who stated that retroactive consent could also be given by the parliament. As such, members of the tribunal, it is my submission that today the claimant cannot in any manner be held liable for such lack of parliamentary consent. And with that, I conclude my sole rebuttal.
Mr. Counsel, just in 15 seconds to respond. Is it your case that you would not have proceeded with this contract in absence of an arbitration clause?
Mr. Arbitrator, I do believe that we would not have proceeded in the absence of an arbitration clause, considering that at the end of the day, given the bias that the courts of Equatoriana have displayed in the past, that would be something that is intrinsically important to us. Thank you.
If I may confirm that I'm clearly audible. Thank you. May I proceed with my submissions? Much obliged. Good evening, members of the tribunal. My name is Kevin Santosh, and I'm the second counsel on behalf of the claimant. I will broadly be addressing the tribunal on two issues. The first, that the PSA is governed by the CASG Convention, and second, that once we assume that the CASG Convention applies, respondent cannot rely on domestic law to avoid the PSA. On the first issue, I have two broad submissions to make. Both the parties to the PSA are contracting states to the CASG Convention, and hence by virtue of Article 11A of the CASG, the PSA is governed by the Convention. Secondly, any intention to exclude the Convention or exclude the application of the Convention must be expressly stated. This was observed by the CASG Advisory Council. In the present instance, for example, opting into the law of or the governing law of a contracting state does not amount to such an exclusion of the CASG. If hypothetically the law of a non-contracting state were chosen, then it could have opted as an exclusion of the CASG, as has been observed in multiple cases, which is why respondent cannot rely on the governing law of Equatoriana as an exclusion of the CASG by virtue of it being a contracting state. My second submission would be that as per the virtue of Article 2E of the CASG Convention, the Kestrel I is not excluded and does not qualify as an aircraft. Article 2E of the CASG Convention intends to exclude aircrafts from the scope of its application. However, it must be noted that the overarching intention of drafting the CASG Convention, as was discussed at the UN Convention wherein the CASG was signed, was that it wanted to draft a convention that applied to as many contracts as possible. The overarching theme was to have uniformity over as many contracts, which is why an exclusion clause should be interpreted narrowly and not broadly, which means all aircraft should not be excluded. There must be certain caveats imposed, because it could not possibly be the intention of the drafters to exclude such a wide variety of goods when the convention history clearly suggests otherwise. In that regard, over time, a very clear requirement has overcome in terms of jurisprudence, which states that when evaluating whether such a good must be excluded or not, it must be seen if it is going to be used for transportation. If it is going to be used for transportation, it falls outside the scope of the convention. But if it is not going to be used for transportation, it falls within. In the present instance, if I may refer the tribunal to Procedural Order number 2, paragraph number 9, on page number 45 of the Moot record. It begins on page 44. Yes. I will summarize for the benefit of the tribunal. This paragraph essentially clarifies the mechanism of the Kestrel Eye, and it states that the Kestrel Eye has a unique but expensive flight stability mechanism. It states that this flight stability mechanism is made to ensure that surveillance requirements are upheld. These are uniquely installed in those drones that are meant for surveillance purposes. Alternatively, drones that are meant to be used for transportation do not have flight stability mechanisms because it is unnecessarily expensive and not required in such drones. Which clearly, I sense a question, Madam Arbitrator. Since they require lower flight stability, this specific flight stability system is often not used to ensure that transportation is the primary purpose of those drones. But this clearly shows that the primary purpose of the Kestrel Eye was surveillance, and hence it does not fall afoul of the CISG Convention's requirement of transportation. If it were to be used for transportation, perhaps respondents' arguments could have stood. But since it is not, the convention does squarely apply. Yes. Indeed, Madam Arbitrator. The authority would be twofold. The first is the CISG Digest, which analyzes cases or jurisprudence over the course of time, which was released by the UNCITRAL, has analyzed cases which say that these are the requirements that are analyzed, and transportation was mentioned in the CISG Digest released by UNCITRAL. That would be the authority on that front. But secondarily, Madam Arbitrator, internationally also, drones and UAVs are in general not treated as aircrafts. I would like to refer to the Montreal Convention on that point. The Montreal Convention has 137 members as the contracting state, and hence is a key indicator of what internationally is considered to be drones and aircrafts. The Montreal Convention clearly states that for a vehicle to be an aircraft, it must be capable of transporting luggage and cargo. In the present instance, the purpose of the Kestrel Eye was to do surveillance and not transportation. Now, at this juncture, respondent may very well argue that, I sense a question, Mr. Arbitrator? Okay. Respondent may very well argue that it was possible that the Kestrel Eye could have been used for transportation and refer to procedural order number 2. But members of the tribunal, while evaluating whether a good is to be excluded from the scope of application of the convention, possibility does not suffice. It's the engineering and purpose of that good. Because it is possible that multiple goods could be used for multiple reasons. But the engineering and purpose is what determines whether or not the CISG convention applies. And hence that argument should not be given credence to, but rather the idea that the Kestrel Eye was designed and engineered, and the respondent also requested it for geographical surveillance purposes should be given credence to, and not the mere possibility of transportation.
What is the law applicable to the contract?
It would be the law of Equatoriana for the purposes of issues 3 and 4.
See page 49. This is on number 251.
Question 51. Yes, Mr. Arbitrator.
This includes UAVs into the scope of definition of an aircraft.
Indeed.
And if that's the law applicable, can the tribunal ignore the parties at the time of the agreement were fully aware UAVs are defined as aircraft?
Indeed, Mr. Arbitrator. Since the CISG convention applies to the PSA, credence must be given to the convention's interpretation of what falls within the ambit of the convention. Article 7 of the CISG clearly stipulates that any questions of interpretation must first be resolved with regard to the convention's international nature, second, as per public international law, and only if these two questions are silent on the issue should you move to domestic law. Hence, the domestic law definition of an aircraft should not be given credence to, but rather the international law definition should be given credence to.
But this is what you are saying. You are trying to tell this tribunal. The CISG itself provides a definition, and that definition should prevail. But that is not so. You are relying on other international law, such as Montreal Protocol or other conventions. But you are not relying on CISG to get the definition of an aircraft.
Indeed.
CISG, in fact, excludes aircraft. And that's why we are at the question that what is the meaning of aircraft and does these drones get included in that or not?
Indeed.
So there is no question of precedence. There is no conflict between CISG and the law applicable to the contract here as far as this point is concerned, in my opinion, Prime Minister.
I would beg to differ on that front, Mr. Arbitrator. The point being that the CISG, while Article 2 stipulates aircrafts, it must be seen what the intention of the drafting history was when defining what an aircraft is and what ought to be excluded. The intention of the CISG over jurisprudence suggests that aircrafts are not blank, not all aerial vehicles are excluded, are treated as aircrafts. Transportation is a key parameter to determine whether an aerial vehicle qualifies as an aircraft or qualifies as something else. Given that, I sense a question, Mr. Arbitrator.
Counsel, what is the source that you're using to arrive at this intention? What is the basis for you to say that that was the intention of the drafters of the CISG?
Indeed, Mr. Arbitrator. When the CISG was being voted upon in the convention's history, a suggestion was made by Germany to suggest that it must clearly be stated that all aircrafts are excluded, to clarify any doubt. But that was rejected, clearly indicating the intention, firstly, that there were certain caveats that they wanted to apply. But secondarily, the overarching theme of the convention has always been to apply to as many sale of contract goods as possible. Following a broad interpretation to treat all aerial vehicles as aircrafts would go against that intention, because a lot of contracts would, just by virtue of being aerial vehicles, be excluded from the scope of application of the convention, which is why a narrow interpretation should be given credence to as per the intention.
Why don't you look at the definition of Article 1 of the Aviation Safety Act, which is at page 36, to answer this question?
Mr. Arbitrator, given that the Aviation Safety Act firstly would, believe the question is, since that clarifies that UAVs are an aircraft, that...
Why don't you see Article 1?
Indeed.
And then possibly
Mr. Arbitrator, since the last line of the article would suggest or would favor the respondents, claimant submissions would largely be that domestic law can only be relied on if the first two thresholds are not cleared. Since the convention's history clearly shows that there is an answer as to what should be treated as an aircraft or not, or even international law clearly showcases what is an aircraft or not, domestic law ought not to be relied on.
Can we read it to mean, assume a situation where this is applicable, but your argument is of course otherwise.
Yes.
It says that where the intention it is for used for moving persons or objects. Now, if your case is that UAV which you are doing is for the purposes of only surveillance and not moving an object or moving a person,
Yes.
why can't you even rely on this definition? While of course the second line goes against you, but
Yes.
that provision has to be read in a manner to give a fruitful interpretation.
Indeed. Indeed, Mr. Arbitrator. Perhaps an alternate argument could be that a conjoined reading of the two clearly indicates the intention that for an aerial vehicle to be an aircraft, its purpose is to transport persons or objects. And hence, that would be an argument in the favor of the claimant on an alternative basis, and I do abide by it on that front. Much obliged. I shall now address the tribunal on the second issue, on how, given that the CSG applies, respondent cannot rely on domestic law to avoid a contract. Members of the tribunal, Article 7 of the Convention clearly states that domestic law can only be relied upon if the CISG is completely silent on a matter. If the CISG deals with that matter, domestic law cannot be relied upon. In the present instance, the matter at hand, respondent may contend, is that of misrepresentation. But I would like to take you to page number 20 of the Moot record. If the tribunal is with me, yes, I shall summarize for the tribunal. Page number 20 is the letter of termination sent by the respondent at the time of terminating the contract. They summarize the matters at hand and they say that the drone eye engaged in serious misrepresentation of the quality of the Kestrel eye. They clearly stress that the issue at hand is that the quality of the Kestrel eye was not up to the mark. But members, questions of quality of the product and not conforming with the quality at hand are dealt with by the CISG. Article 35 of the CISG Convention squarely deals with this and talks about conformity of the quality of goods provided, which means the respondent is precluded from relying on domestic law since the convention does address this issue. But members, alternatively, even if you were to assume that respondent could rely on domestic law, I will submit that those requirements were not met. Article 3.2.5 of respondent's domestic law is a mirror image of the unidroit principles of international commercial contracts. They have two aspects to it. The first, that there should be a fraudulent representation, and second, there should be a fraudulent non-disclosure of relevant circumstances. Claimant will contend that neither has happened. On the first instance, there has been no fraudulent representation. For this purpose, I will give you a timeline of events. In March 2020, the respondent released a tender calling for state-of-the-art aircrafts and UAVs. In December 2020 was when the contract was ultimately concluded and signed. During this period, there was only one good by claimant that was on the market, the Kestrel. That was the only good that was finalized. Now, respondent may contend that the Hawkeye was in preparation stages, it was in developmental stages. But it is key to note that when the contract was being signed, the Hawkeye was simply in the testing stage. It was still being tested out whether it could fly, what is the takeoff reliability, what is the likelihood that it will not crash. All these things were still being developed. I sense I'll soon run out of time. May I seek an extension of 1 minute to conclude this issue? Much obliged. Which means when the contract was being signed, the Hawkeye was still in the testing stages, which is why it was right for the claimant to contend that the Kestrel was the top model at the point in time when the statements were being made. And I sense a question. Yes.
Was the requirement for it to be state of the art, or was the requirement for you to provide the available documents?
The requirement was state of the art. And claimant submission would be that at the point in time when these representations were made and the contract was signed, it was the Kestrel that was the state of the art. Because state of the art means the highest technological advancement present at that point in time. Given that the Hawkeye was still in the testing stages, it was still not finalized as a product. We wouldn't know the feature of the Hawkeye. It would not qualify as state of the art. But the Kestrel, a finalized product, would be state of the art. That brings me to the final leg of my submissions. For 3 reasons, that would not be the case. The first is, and respondent may rely on the Supreme Court judgment of Equatorian law. Factually, that judgment is very different. It dealt with a scenario where a state-owned enterprise was newly formed, whereas this is a state-owned enterprise existing for half a decade. Factually, these are very different. But even if you assume that they do exist, the judgment also clarified the scope of disclosures. It said that all information relating to improvements on that product must be clarified. There were no improvements planned for Kestrel. Hawkeye is an entirely different product. So that obligation disclosure does not fall on the Hawkeye, but simply on the Kestrel. If I may seek 30 seconds to answer Madam Arbitrator's question and conclude the issue. Much obliged. And the third reason is that the information is not pertinent. Ultimately, the Kestrel met all the requirements of the respondent. All parameters were fulfilled, it was state of the art, and it fit the budget. The Hawkeye was more than 100% more expensive. It would have been a $90 million contract and not a $45 million contract. So respondent can't contend that we wanted that when that was clearly outside all the requirements stipulated by the respondent, and hence there was no obligation to disclose since it was irrelevant as a product, entirely different to the requirements. So on all these 3 fronts, there has been no fraudulent non-disclosure and no good faith obligations breached by the claimant, which is why ultimately the respondent cannot rely on Article 3.2.5 and the claimant must prevail. Yes, Mr. Abri, it is still in production and will be phased out gradually by the year 2023.
So meaning thereby it is a product that has become obsolete and the newer model that is Hawkeye ultimately is taking over.
Of course, Mr. Operator. If the contract were to be signed today, perhaps we would have spoken about the Hawkeye. But since the contract was signed in December 2020, at that point in time, it was the latest model. And since fraud should be evaluated at that point in time and not retrospectively, we would submit that.
This is only to test your response to my colleague's question.
Yes.
That is why I posed this question.
Of course. Yes.
I don't have time, but you say still phased out till 2023.
Yes.
But if you see answer at page 45, question number 13, it will be phased out at end of 2024.
Yes.
So it's a lot of time still.
Absolutely.
Still in the market. 1. 2, you said that you see question number 14, which says that Hawkeye was at the 10th stage, and you could have in fact delivered 3 of Hawkeyes by 2022. So why can't you do this? Even these drones of Kestrel, you are going to deliver in 2022 only. Now the fact that you have got 3 Kestrel from the company which is gone insolvent, that you are trying to put it on the government. So why wouldn't the government want to have something which is more advanced, technologically advanced, more helpful for them, and price, of course, they can negotiate it.
I have a concern, Mr. Arbitrator, and I would have a 2-pronged response to that. The first is that at the point in time when the contract was signed, given that the Hawkeye was still in the testing stages, at that point in time, it would be unclear if the Hawkeye as a product would be finalized, ready for the market, whether all the proprietary IP requirements would have been met. Perhaps retrospectively, the respondent may contend that you could have delivered it. But in December 2020, it is unclear if that would be the case. But secondarily, overall, the Kestrel I is the better product for the respondent's requirements, not just on budget.
Let them decide. Thank you.
Indeed, Mr. Avatar, yes. Mr. Abrata, I believe the prop is silent on that fact quite clearly, but currently we are aware that by 2024 it is going to be phased out, yes. Not entirely clearly, yes. I thank the tribunal for a kind and patient hearing.
Members, if I may proceed. Good evening, members of the tribunal. My name is Abhyuday Singh, and I shall be advancing oral argument on behalf of respondent on the issues of merits. Members of the tribunal, throughout its submissions, claimant has sought to establish two things. First, it has sought to establish that the CISG governs this contract. And second, it has sought to establish that as a consequence of the CISG, the respondent is not entitled to its domestic law remedies. Members of the tribunal, these are severe mischaracterizations of both the nature of the transaction between the parties and the nature of respondent's claim. Through these mischaracterizations, claimant wishes to apply the CISG to questions which the convention specifically does not govern. And accordingly, I will be mirroring the respondent's submissions and making two submissions before you. First, that the CISG in fact does not govern the PSA. And second, that even if you apply the CISG to this contract, the respondent is still entitled to its domestic law remedies for fraud. Moving to my first submission. Members of the tribunal, claimant has relied on Article 1 of the Convention and relied on Article 2, Subclause E. Taking respondent on its best case and assuming that you attempt to apply the CISG to this contract, I will establish why that is simply not possible. This is because the CISG itself does not wish to govern this transaction. It specifically excludes 4 items of freight from its scope of application under Article 2. These items are ships, vessels, hovercraft, and aircraft. Now, members, while it is true, as claimant has clearly stated, that transportation is a key element as to what constitutes an aircraft, I submit that it is not the intention of transportation, but the capability of transportation. As such, CISG case law, notably the yachts case of 2021, has focused on the capability of the good and not only its intended use. To illustrate my point, members of the tribunal, if you were to buy a Boeing 747, but remove its cargo-carrying containers and place geosurveillance equipment on it, the Boeing 747 would still be an aircraft. If claimant submissions were to be accepted, the tribunal might as well apply the CISG on such a transaction. Members, therefore, the intended purpose of the goods should not be given primary determinative value by this tribunal. Even if you try to ascertain the intended purpose, that is not possible in this case. To illustrate this point, if I may guide you to page number 5 of the record, which is the claimant's own notice of arbitration. 5, Mr. Arbitrator. On page number 5, on paragraph 5, claimant itself has admitted in the 4th line from the bottom, at the very end of that line, the very favorable price in combination with identified potential additional fields of use resulted in an increased volume of the transaction. Members of the tribunal, the parties were envisioning additional uses for the Kestrel I, which included the transportation of cargo, before the contract was ever signed. This illustrates that the intended purpose of the parties was at best ambivalent and not capable of absolute ascertainment by this tribunal.
It could have been expanded that way.
Yes, Mr. Arbitrator, it could have been expanded. And in fact, the statement of the respondent on page 33 of the record shows that it was expanded. On page number 33, which contains a quotation by Mr. Rodrigo Barbosa, who was the minister responsible for the operations of respondent. On the right-hand side corner, in the 12th line from the bottom, in the middle of the paragraph, the minister is quoted as saying, "A drone which normally carries cameras or other surveillance equipment in its cargo compartment should also be able to transport urgently needed spare parts or medicine to the remote parts of Equatoriana." Not only this, members of the tribunal, the scope of the contract was also enlarged following additional fields of use. So this clearly illustrates that not only the key determinative factor is the capability of the vessel, but even if you go by the intention, the parties did in fact intend to use these goods for the transportation of cargo. If again, moving to the point of internationality, as was raised by the claimant, I would like to point you to jurisprudence and treaty practice relating to the Chicago Convention on Civil Aviation, according to which pilotless aircraft are considered aircraft. Specifically, through the RPAS manual released by the ICAO in 2015, remotely piloted air systems are considered at par with normal conventional aircraft so far as international treaty practice is concerned. Even under the internationality requirement, this shows that the Kestrel I-2010 can be considered aircraft. Now, members, allow me in the final part of this submission to illustrate why the Kestrel I has the capability to be used as an aircraft. If I may guide you to page number 15, which contains the general technical requirements of the Kestrel I. On page number 15, if you would direct your attention to the table titled Performance, members of the tribunal, it's clear that the Kestrel I can fly for 13 continuous hours at a height of 6 kilometers and a maximum speed of 250 kilometers per hour. Now, if you would direct your attention to the table titled Dimensions and Weight, the third entry from the bottom puts the payload capacity of the Kestrel I at 245 kilograms. Members of the tribunal, we are talking about a flying machine capable of flying for numerous number of hours at high speeds and carrying 1/4 metric ton of cargo. This has the capabilities of an aircraft. It's built like an aircraft. It clearly is an aircraft. Now,
Counsel, why don't you see question number 9, in fact, the answer 9 at page 44.
yes, Mr. Arbitrator.
In fact, you could see from there that while they are capable of carrying humans as well, but that has been done only in the cases of emergency and not as a regular scene. And in fact, what the claimant also suggested, that the costly flight stability has been given to them because of the kind of nature of work they do, surveillance. So while it may be capable to do it, but usually it is not used for that purposes. So while I understand your argument of intention and capability of course, but the intention of the party since the beginning was very clear that it will be used only for the purpose of surveillance, and at best in the emergency circumstances, medicines and all can be given to that area, wherever they are. So the parties never intended for it to be used for the purpose of transportation. So intention is also very clear at that point in time.
Mr. Arbitrator, while at this time, the tribunal knows the representations of claimant with respect to how viable it is to carry cargo, it was not known to respondent at that time. At that time, respondent in fact expanded the scope of this contract once it got to know that these drones could be used for the carriage of cargo. This shows that not only Not only did the parties know of this capability, they changed their behavior following this knowledge. This shows that this was a concrete intention on the part of the respondent to use these drones for the purpose of transport. Maybe as a secondary purpose, I agree, but a purpose nonetheless.
So just to clarify and bring you back to what you started from, is it your case that the purpose for which the drones were used, or UAVs were used, is the determinative factor? Or is it your case that irrespective of the purpose for which they're used, if they're capable of transportation, then they're used?
Madam Arbitrator, it is the capability of the drones. If I may now move to the second part of my submission. Members of the tribunal, claimant again has mischaracterized respondent's claim. Respondent has not made a claim of non-conformity. It is not claiming breach of contract. It is claiming fraud. And as such, fraud raises an issue of the validity of this contract. And according to Article 4 of the CISG, the validity of contract is not governed by this convention. Regarding the claimant's argument with respect to the notice of termination, allow me to point it to you again on page number 20 and establish why this is in fact a case of fraud. Members of the tribunal, the claimant had read to you paragraph number 3. In that paragraph, it stated that the respondent, Ms. Wilhelmina Queen, had alleged that Drone Eye engaged in serious misrepresentation of the quality of the Kestrel Eye 2010 drone. Members of the tribunal, what Ms. Queen is saying here is not only that the Kestrel Eye did not meet its expectations under the contract, but the respondent entered into this contract in the first place because of these misrepresentations. Respondent from the start of these negotiations wanted state-of-the-art goods. And it entered into this contract with that expectation in mind. Claimant represented the Kestrel Eye as its latest goods, and subsequently, 2 months after the contract was signed, rendered them obsolete. Members of the tribunal, this shows that claimant has basically sold old goods as new to the respondent. Respondent would never have entered into this contract in its current form had these misrepresentations not been made.
Counsel, on the date on which the agreement was entered into or the bid was issued, was there a product better than the Kestrel Eye in the market?
Mr. Arbitrator, I do not have information in that regard currently. However, there was another bidder, Air Systems PLC, whose bid was rejected in favor of claimant because of claimant's representations.
Exactly. So the claimant's product was found to be the most appropriate product for the contract?
Yes, Mr. Arbitrator, at that time.
At that time. And is your argument that subsequent new product being launched either by the claimant or by any other party changes the nature of the product as on the date of the agreement or the bid?
Mr. Arbitrator, it is not that, given the purposes, my submission, allow me to clarify my submission to you. It is not the submission that you must analyze whether the goods are latest today, but whether the claimant should have disclosed these matters or not. I am merely trying to highlight that such questions which reflect pre-contractual disclosure requirements or requirements which relate to fraudulent inducement are beyond the convention scope. However, on the factual matrix of your question, I would like to point you to the used car case, which was delivered by the Court of Appeal of Kern in 1996, in which a similar case of non-disclosure was being heard. In the used car case, the court recognized that knowing non-disclosure about defects or future defects which may occur can be dealt with by the convention under Article 35. But at the same time, that does not exclude remedies for fraud. If I may move on, and if I may have half a minute to conclude my submissions, members. Members, even going by the operative facts of this particular claim, you will have to determine at least 4 things which are beyond this convention scope. First, the freedom of consent, which is not governed by the CISG. Second, pre-contractual disclosures, which again is beyond the convention scope. Third, state of mind. You will have to determine whether claimant's state of mind was fraudulent, negligent, or innocent, which again is beyond the convention scope, and all that leads to validity of contract. Thank you.
If I may confirm that I'm audible. Thank you. Members of the tribunal, I have one point of rebuttal. The most important fact in the present case is that the contract was signed in December 2022 and Hawkeye was released after it, more than 2 months after it. At the point of time when the contract was being signed, the model that they're talking about was still in the testing stages. The model that was ready and on the market was presented at the top as the top model and state-of-the-art aircraft. But the model that was not ready was not presented. So it is a foul to say that there has been fraud or misrepresentation. Indeed. Madam Arbitrator, Franco Ferrari, in his commentary, the Uncitral Digest, had observed a very interesting case. He said that robots are often used for recreation. It probably has 2 people going on a canoe on a river. In times of duress, perhaps you could transport 10 people if there's a flood, but that doesn't mean that it becomes a ship. In times of emergency, it's possible something could be used for multiple purposes, but the engineering, the purpose of creation of that product is what is determined by the convention. Perhaps in emergencies, they could have used that for transportation, but their own intention to use it for surveillance, the engineering of the flight stability system to be used for surveillance clearly indicates that it falls within the convention. It is not for the purpose of transportation. So purpose and not capability or possibilities, because the convention does not deal with externalities or possibilities, but rather the core premise of that good, which is why that's the more detrimental factor. Indeed. And that concludes my rebuttals. I thank the tribunal for a kind and patient hearing.
Members, if I may. Thank you. Thank you. Members, 2 rebuttals to the rebuttals made by claimant. No, it's on the same rebuttals, Mr. Arbitrator. I apologize for that. First, with respect to whether the goods were latest on the date upon which the contract was made. Members, the respondent's expectations, and which is known to both parties, was geological surveillance. This is a long-term contract. Merely because the good was latest on the date does not mean that it will meet respondent's purposes. In any case, the purpose of establishing all of this is the right of access to domestic law remedies. The tribunal may very well determine that there was no fraud, but all respondent is asking for is an opportunity to establish that. Secondly, members of the tribunal, on the point of capabilities and purpose, no CISG case law has followed the intended purpose test. Rather, they have looked at the capabilities of the goods involved. Even a Russian decommissioned submarine, which was not capable of being propelled on its own, has been considered a vessel under Article 2. Such a case clearly determines what the law is and what the law prefers. Thank you.
Members, if I may seek a 15-second response to that, on just that last case law. That case law would actually favor the claimant because a decommissioned submarine is not possible to be used as a submarine, but the engineering of the submarine meant that it was disqualified, which means the purpose or the engineering is to be looked at. So that case law does squarely favor claimant's interpretation of the Castelli's interpretation of surveillance. Indeed. So broadly, claimant submission is that the engineering and purpose of the good is to be looked at, and not whether it is possible to do X, Y, Z. The case law that respondent cited clearly said that a decommissioned submarine was still treated as a submarine. A decommissioned submarine cannot possibly be a submarine, but it is engineered to be a submarine, which means they also agree that the engineering and the purpose is the determinant factor and not possibilities.
If the tribunal would allow me another 10 seconds. Thank you, members. Members, on that point, a surveillance aircraft still remains as an aircraft. The engineering of the vessel, while it is important, it is what possible uses are the good is capable of through that engineering. A decommissioned submarine is not capable of propelling itself. There are no motors in a decommissioned submarine. If that vessel can be considered as a vessel under the CISG, clearly a flying machine which is capable of flight and capable of carrying cargo must be considered as an aircraft.
I think the point that is being made here is this pen can also be used to throw at somebody to wake them up. But the ultimate and authorized use of this pen is to write. So what is the authorized use of this pen? That is to be seen. Of course, it can be used in multiple ways. In an unauthorized manner, in case of emergency, one can use this bottle for something else. So similarly, the authorized use of this product, whether the authorized use would include transportation or not.
And in addition to what my learned brother has said, also you see the purpose of this Article 2. Why they are excluding the applicability of this convention on these goods. See the nature. See A, it is for goods brought for personal, family or household use and all. See second, where you are by auction, on execution otherwise authority of law, of stock, share, investment securities, then of ships, vessels, hovercraft, or aircraft, and of electricity. All of these are in nature of something which falls under the sovereign domain of a state. And therefore, you don't go for conformity, because the entire idea of this convention is to have conformity of the law for sale of goods applicable in entirety of everywhere, whosoever has party to this convention. So ultimately, you will have to see what is the purpose. Capability, in my view, of course, from SI, may not be the relevant factor. So therefore, purpose becomes relevant because that is the purpose which is in research, of course, by the convention itself.
Of course, members. If I may take another 20 seconds to answer your concerns. Thank you. With respect to authoritative use, I would again like to point the tribunal to the decommissioned submarine case, another aspect of the case. The submarine, while being without a propellant system, was being sold for salvage. It was being sold to be torn apart. Yet, the convention was excluded. It is not the intended or the authorized use, what courts have looked at repeatedly. It is the capability of the goods. Similarly, yachts have been excluded and leisure boats have also been excluded. They cannot be used as items of freight. And clearly, still, they cannot be intended to be used as items of freight, but clearly they can be, which is why they were excluded. With respect to the second question, Mr. Arbitrator, apologies. On the point of domestic law registration requirements and whether the state would consider this an aircraft, Equatorianian law, via Article 1 of its Aviation Safety Act, would actually consider these drones as aircraft.
Only if it is to be used by a private party. But if the government is using it, they don't need registration.
Mr. Arbitrator, that is because the state does not need to trace its own aircraft. It is when the aircrafts are used privately, does the government need to regulate their use in public policy purposes. When the state itself is using it, it can ensure that such discipline is followed for its own
This
aircraft.
is also, if it was gone through the state, would have used only used it. Not the private party.
What this illustrates, Mr. Arbitrator, is that it is merely for administrative convenience that a registration requirement is not placed on these drones, but that domestic law nonetheless would have considered them as aircraft.
Not at all.
all the teams and spectators are requested to stay back because the results will be declared after this. So just, we request not to stay. Thank you.